Namaste and welcome. The presentation is on debentures. Debentures, with reference to Companies Act, is under Chapter 4 and it is indicated under Section 71. Rule 18 under the Companies Share Capital and Debentures Rules 2014 makes elaborate provisions regarding debentures. We will be studying debentures with reference to Section 71 and Rule 18 together. If we look into the scope of debentures, we find here initially we are talking of what is being issued, for how long, and how it is secured, and there is a mention of trust deed, which is headed by a debenture trustee, and there is a debenture redemption reserve being mentioned about, and we have remedies from the tribunal depending on the grievances that we have. If we look into the overall picture of this, the focus is on protecting the interest of debenture holders by having a strong trust deed and a strict monitoring to ensure there is payment of interest regularly and repayment of the principal as and when it is due, and there is no default. Needless to say, debenture is a debt raised by the company to finance its requirements, and this entire trust deed and the mechanism of debenture trustee ensures that the amount of debt which is raised by the company is used on the project it was meant to be invested on, to ensure that the amount goes into the right project and the risk is not enhanced by its diversion. Let us proceed further. From this overview, we will be shifting to chapter-wise understanding of the topic of debentures. To start with, we will go through section 71 and understand by going through the definition of debentures under section 2 subsection 30, and then look into what is specifically mentioned in section 71. It will be quite interesting to see the definition of debentures under section 2 subsection 30. It says debenture includes debenture stock, bonds, or any other instrument of the company. It evidences a debt and it might constitute a charge on the assets of the company or not. To say, it can be a stock or bond or instrument but issued by the company. It is a debt instrument. It can be secured or unsecured. And section 44 of the Act says it is to be treated as a movable property transferable in the manner provided by the articles of the company, which is a point just to be noted that it could be transferred as an instrument and it could be secured or unsecured. Let us come to section 71 to find out what it talks about. Section 71 says any issue of debentures has to be approved in advance by a special resolution in the meeting of members. Then it goes on to say the debentures can carry an option to convert, means it can be convertible debentures which can be converted into shares, and the conversion could be full or part at the time of redemption. Just to say, members by a special resolution approve the issue of either fully or partly convertible debentures or pure debentures with no conversion option at all to the investors. And second point, it says company cannot issue a debenture with voting rights. Voting rights is the prerogative of the equity shareholders. Number 3, the debentures issued by a company shall be secured with the support of the assets being attached to them as a security. Number 4, it says there shall be creation of debenture redemption reserve. It is just like building up a sinking fund provision for repayment of debentures as and when it falls due. And this reserve has to be created out of profits which are otherwise available for dividend. Means you should create it out of distributable surplus. And this redemption reserve shall be used for redemption of debentures. This reserve has got the spirit of ensuring prompt redemption of debentures, and company is required to pay interest and redeem the debentures as per the terms of the issue. These are the points which section 71 makes out. In addition to that, the section further states the company shall comply with the following conditions before issuing secured debentures. What are the conditions which we need to look into? The date of its redemption not to exceed 10 years. Means it has to be redeemed at the end of 10 years. It cannot go beyond that. But it gives an exception also. In case of infrastructure companies or infrastructure finance companies or other companies as permitted by central government, it can go up to 30 years. Duration of debenture exceptionally could go to 30 years, but in the normal course, it cannot exceed 10 years. Then second point, it says it has to be secured by a charge on the properties. And the property may belong to the company or to its subsidiary or to its holding or to its associate companies. But debenture should have a security. They are not naked debentures, they are secured debentures. Guarantee of payment. Then third point it says, before issuing the letter of offer in respect of debentures, the company has to appoint a debenture trustee. Debenture trustee is the representative of debenture investors, and he has to be finalized before the process starts. Therefore, they say letter of offer has to be issued only after you appoint the debenture trustee, and his name will be mentioned in the debenture letter of offer, and a debenture trust deed has to be signed. It is an agreement between the company and the debenture trustee, laying out the terms and conditions of mutual safety. It has to be executed within 60 days of allotment. And next point it says, it is responsibility of the debenture trustee to take all steps to protect the interests of debenture holders and look into all their grievances. He is a representative of debenture holders who should take care of their interest as well as their grievances. And there is a word of caution here from the section and the relevant rules under Rule 18. Any trust deed which is lenient on the trustee and exempts him from liability for breach of trust, it shall be void. Trustee is responsible to be diligent, careful, and act trustfully. If there is a breach, he has to be punished. But if there is a clause in the trust deed which says, no, the trustee could be exempted, no, such clause is not acceptable and it shall be void. However, there is an exception to that. If the majority of not less than 3/4 of the debenture holders agree, such exempting clause in the trust deed can be valid. It need not have to be void. That brings us to the second part of the study, which is trust deed, which we will study in detail. Let us study the key clauses of a debenture trust deed and understand functionally how does it help the debenture holders. The debenture trust deed is signed between the issuing company and the trustees, and it will be in a standard form of SH12. And what the trust deed talks about? The company, one of the parties to the trust deed, agrees with the trustees that they will pay the principal as and when it becomes due, and they offer security of assets and also will pay interest to debenture holders. It is just like reassuring your principal and interest shall be paid on time. And in consideration of the debentures, the debenture trust deed says the company agrees to mortgage to the trustees the fixed assets which are supposed to be given as a security for the due payment of principal money and the interest. To put it the other way, the trust deed is an agreement of offering security to the debenture holders by executing a deed detailing the plants, properties, or assets which are identified and linked as a security to the debentures. And a trust deed is a document which is available for inspection. It's open for inspection by any member or debenture holder, as if it were a register of members which is open to members. And a copy of that can also be requested for, which will be delivered within 7 days on payment of a fee. This is in terms of administrative part of the deed, which is available for inspection of any member or any debenture holder. The deed will also indicate one special part here now. It says, or it will list out as a part of the agreement, that in certain special circumstances, with no further delay, the debenture money will be due and payable immediately, and the security covered by the deed becomes enforceable. These are emergency situations where the security of repayment is at stake, and the debenture trustee and the debenture holders have to take a decision. And this will be agreed in the deed in advance. What it says? If the company makes default in payment of interest or principal at any point in time, we can enforce the trust deed. Or if the company ceases to carry on its business, we cannot wait. We can forthwith enforce. If there is a court order which winds up the company, once again, as secured creditors, we come into picture. If there is a report from the auditor of the company under the Act that company's liabilities are in excess of its assets, it talks of the solvency of the company. In this case also, it is immediately payable and security enforceable. Or if the trustee is of the opinion that the security of debenture holders is in doubt or jeopardy, they feel it is quite risky. In this case also, the debenture will fall due immediately and the debenture trustee will be entitled to enforce the security and force the company to hand over the things to the debenture holders. What they will do when it is enforceable? They will enter upon and take possession of the mortgaged premises, number one. Number two, they will immediately call a meeting of debenture holders to decide what should be the future course of action. Debenture trust deed that way lists out the possibilities of remedial measures to be taken depending on various situations, and it calls upon the trustee to act in time to protect the interests of the debenture holders. Having seen the trust deed, we will now have a look at debenture trustee and certain specific aspects as regards the position and the person going forward. The debenture trustee is an important position and a person because he is the spokesperson and protector of interest of the debenture holders. Section 71 highlights a few points which are worth noting here now. It says the name of the debenture trustee has to be stated in the letter of offer which is given to the subscribers before they apply for the debentures. And it should also appear in all subsequent communications because he is the spokesperson. And before indicating his name in the letter of offer, the company has to appoint him and get a written consent. And the fact that he has consented to be named as a trustee has to appear in the letter of offer. Consent and name in the letter of offer. And the debenture trust deed, which is the formal agreement, section 71 says it has to be signed in within two time frames, that is 60 days of allotment or within 3 months of the closure of the offer. Normally, if the allotment is done within 30 days of closure of the offer, then it becomes 90 days from the closure of offer when it comes to 60 days after allotment. It is the same thing which is put in two ways to protect the interests of the debenture holders. And when the charge is created, it is the debenture trustee in whose favor the documents are made because he is the fiduciary relationship holder with respect to debenture holders. And his is an important position. Supposing there is a vacancy in the office of debenture trustee, the board can fill it up if it is in the normal course, because there should be a trustee always. But if the debenture trustee has resigned for any reason there is a concern for debenture holders, and any replacement of him has to be with the written consent of majority of debenture holders. This is all seriousness of the reasons which compel the debenture trustee to resign. The debenture holders will have to take care to understand the rationale behind the resignation and how it has to be filled up. There is also a provision that if not less than 3/4 of the debenture holders agree, a trustee, for whatever reason, be removed before expiry, because it is a position of trust and confidence, and if the debenture holders have lost confidence in the trustee, then if 3/4 of the debenture holders agree that he be removed, he shall be removed before the validity expires. Any candidate for appointment as a debenture trustee should not attract disqualification. As per subclause C, a person attracts disqualification if he holds shares in the company, or he is a promoter, director or key managerial personnel or employee of the company, its holding company, subsidiary or associate, or he is in receipt of monies from the company otherwise than as remuneration payable to trustee. It is a beneficial interest which he holds, another parallel source of income to him. He is disqualified. He owes money to the company. He is indebted to the company. He has got that commitment either to the company or its subsidiary, holding, associate or subsidiary of holding company. He has got a relationship running contrary to the position of a trustee. He must have given a guarantee to the company in respect of debt of the company, maybe debentures or interest thereon. He attracts disqualification. Or he has dealings with the company to the extent of 2% or more of its income, annual income, or rupees 50 lakhs, whichever is less. He deals with the company to the extent of this volume. That pecuniary relationship is established during the 2 immediately preceding years or during the current year, in which case his relationship is established, he is disqualified. To be appointed, this is all before he is appointed. Or he happens to be a relative of any promoter or an employee or a key managerial personnel of the company, related to the top management as a family member. He cannot be taken as debenture trustee because he becomes an insider, whereas debenture trustee is a position of fiduciary relationship. As we observe, debenture trustee is in a very important position, and his profile is so rich that he has got a lot of duties to do simply 2 things: to protect the interests of debenture holders, and number 2, to see that their payment, whether it is interest or principal, is made on time. Now the rules list out what are his duties. A debenture trustee has to compare letter of offer with the terms of the issue and the trust deed. Are they matching? Is there any difference between the trust deed and the letter of offer? It is a matter of ensuring terms are consistent. Number 2, none of the conditions are prejudicial to the interest of debenture holders. That is ultimate in his mind. He has to get periodical performance reports from the company to assess, are the things moving as planned. He should communicate with the debenture holders on payment of interest or redemption on an ongoing basis and take action. And there are situations when some risk is smelt. Say for example, there are two defaults consecutively in payment of interest, or there is a default in creation of security as per trust deed, or there is a default in redemption of debentures. Now these situations make you doubt, are things going right, or are we knowing the things happening within the company? In these situations, he can immediately act to ensure that on the board of the company, they have a representative as a nominee director, so that he comes to know as to what is happening in the operation of the company by participating in the board meeting. Therefore, appointing a nominee director depending on certain happenings is one of his duties. Whenever there is a breach of the terms of issue, he has to take immediate steps to remedy the breach. Nothing should be allowed to drag or drift. And he will also inform the debentures holders whenever there is a breach, post haste. There is no delay at all, it is forthwith. And he has to always oversee whether the debenture redemption reserve is being properly calculated and properly created from time to time, because that is going to be the source for redemption of debentures. It has to be built up safely. And he should always have a look at the assets of the company, because they are the basis for them to have safety of repayment later. And he should always ensure that the company and the assets that they have given are sufficient to discharge the principal and interest at all times, and they are not pledged again to someone else. They are free from any other encumbrances. His duties are so much that he has to do things as necessary to protect the interest and guard the security received by them. And it is also essential for him to ask the company to give reports on, are the funds used on the projects as mentioned in the issue document. For example, you have collected debentures for building up a plant expansion, while you are using that money for some operational expenses of working capital. That is spelling danger to you. Therefore, he has to call for reports on where the monies of the company being utilized. Are they following the estimates given in the budget or in the letter of offer? Debenture trustee also has a duty to convene the meeting of debenture holders. There are two situations where he has to convene a meeting of debenture holders. Number one, when 10% value holders of debentures requisition a meeting, they sign and give a request, we want the meeting to be held, he has to hold it because 1/10 in value has requisitioned. Or if there is any event of breach or delay in payment of interest or failure to pay interest, he can call a meeting of debenture holders. And he should ensure that either conversion in case of convertible debentures, redemption in case of the non-convertible portion, it happens in terms of the issue on time in the right value and volume. And to put it in a gist, the whole job of debenture trustee is only one: protect the interest of debenture holders, be it principal or interest. That is his paramount job, and he should always look into protecting the interest of debenture holders and also resolve their grievances. Let's understand in greater detail the concept of debenture redemption reserve. Building up debenture redemption reserve is one of the commitments under the debenture trust deed. There are two aspects to this. One, the debenture trust redemption reserve is created and it is invested in specified securities. Creation and investment in securities so that it is available on maturity for repayment. And it is always linked to the debentures which are falling due for payment during the year ending 31st March. We can note the points one by one. Debenture redemption reserve always comes out of profits of the company. If you don't use the profits for debenture redemption reserve, it should be such that the amount is available for payment of dividend. This is to say, it is always created out of revenue profits. It is not created out of capital profits. Therefore, they say it has to be created out of amount available for payment of dividend. Number two, it also talks about the adequacy of the provision made. The reserve made during the year should not be less than 15% of what is maturing during March next year. That becomes a yardstick or basis to link what is maturing. Are we creating a reserve at the minimum of 15% of that? And debenture redemption reserve has to be created to the extent of non-convertible portion. It goes without saying, because the convertible portion doesn't get paid off because it is converted into equity. And it is agreed that the amount of debenture redemption reserve which is invested has to be used for a single purpose. The purpose is only redemption of debentures. It cannot be deployed elsewhere or it cannot be diverted elsewhere. It is a dedicated reserve. How the amount is invested? It could be invested as deposits with the scheduled bank, commercial bank, or it can be invested in unencumbered securities of the government, central or state government. Unencumbered means it doesn't carry any lien on that. It is always freely available. And there are certain securities listed under Indian Trusts Act as unencumbered under different clauses. They could also invest in those securities. The whole idea behind this investment is liquidity of the amount, safety of the amount, and also some return on the amount as return on investment. All these are to be taken into account while keeping the money invested in the unencumbered securities or deposits with the bank. And one has to cross-check always that whatever amount which is put into debenture redemption reserve during a year, it doesn't fall below 15% of the debentures maturing during the year ending 31st March. Now it is time to learn about the remedies available from tribunal and other related provisions. The debenture trustee has two opportunities to approach a tribunal for a remedy. One, in anticipation, depending on the prevailing situations. Second, on the occurrence of an event. Let us take the first one. At any time, the debenture trustee is of the opinion that the company has assets which are likely to be insufficient to meet its commitments of debenture trust deed, fearing that there will be a disaster, he can petition to the tribunal, submit an application to the tribunal, seeking what? It is to put restrictions on the company not to incur further liabilities. Because if the company goes for further liabilities, the interest of the present debenture holders will suffer. And to bring a stay on incurring further liabilities, tribunal could be approached by the debenture trustee. This is in anticipation of a problem, provided he is convinced that there is a risk to the interest of debenture holders. Second, when there is a failure. On the occurrence of a failure, either to redeem or to pay interest, the debenture trustee can immediately approach the tribunal, and the tribunal, in both cases, in the earlier case and in this case also, it will always hear both the parties and it will give a decision. In the first case, it may ask the party to stop further liabilities, and in the case of actual failure, it can direct the company to enforce the security that they have and force the company to redeem the debentures immediately without waiting for any more delay. These are the two situations where tribunal can be approached. And as we know, tribunal orders are court orders. They are to be complied with. If there is a default in complying with the order of the tribunal, it has got extensive punishment to the officer in default, ranging from imprisonment to fine or both. And we can also make note of 2 points. Any contract to take up debentures by the debenture holders is a contract which can be enforced by the company as a subject of specific performance. If someone has agreed to buy 100 debentures, he has got to buy it. There is no option of going away from it. We can get a order from the court on the specific performance of that. And as regards debentures, the whole area is the discretion of the government, which can prescribe various rules, just like Rule 18, for the sake of management of debentures, their issue, redemption, interest, process, debenture redemption reserve, etc. That discretion is given to the central government to make the relevant rules. To summarize, we have seen what a debenture is as a debt. Secured debentures are issued by the company. They can be issued for 10 years. In case of infrastructure projects, they can go for longer duration, and the trust deed has to be executed within 60 days of allotment or within 90 days of closure of issue. And we looked into the trust deed, its clauses. It is a contract between the company and the trustee. It creates mortgage and it is available for inspection, and a copy could be taken of it, and its detailed contents give a right of safety of redemption to the debenture holders. Debenture trustee is an important position. His name has to be there from the beginning in the letter of offer. His casual vacancy, how it is to be filled up, when he can be removed, what are his disqualifications to remain a fiduciary person, And what is his ultimate duty of protecting the interest of debenture holders? Debenture redemption reserve as 15% of the debentures falling due during the year ending 31st March, and their investment in liquid assets in scheduled banks to earn reasonable return and keep it safe for redemption. And the amount has to be available for redemption and it should not be used for any other purpose. And we also saw the help that we get from tribunal in when we approach them in anticipation of trouble or after the breach has occurred. And we also saw the discretion of central government to prescribe relevant procedures. A quick summary for a ready recall. Thank you so much. Thanks a lot.